The gentlelady from California.
Thank you, Mr. Chairman. I would note that Mr. Nadler's question has not yet been answered, but I want to start by asking that out of respect for the American public and the Epstein survivors, some of whom, of course, are here today, that we can have a transparent conversation and get the public the answers they deserve. I want to briefly direct your attention to two documents I'm hoping we will put up on the screen.
The American public is watching a breakdown of the rule of law. It is happening in real time inside a congressional hearing room. Victims of a global sex trafficking ring are sitting just feet away from the person sworn to protect them, but the Attorney General of the United States is not looking at them. She is looking at a binder of personal attacks. She is using the Department of Justice to track the computer searches of the people who oversee her. She is claiming there is no evidence of crimes, while her own files are filled with witness statements and redacted names. This is not a political debate. This is a forensic examination of an institutional failure. This is the evidence of how the law is being dismantled by the people who are supposed to enforce it. Let's play this clip.
First, an individual emails Jeffrey Epstein asking whether a woman identified as M was pro or civilian, and Epstein responds that she was a civilian, Russian, and fun. In the second email, Epstein writes to Steve Tisch about a Ukrainian girl, noting that she was, quote, a little freaked out by the age difference and stating that he would try to convince her not to return to Ukraine. He then instructs Mr. Tisch to call him, adding, I don't like records of these conversations. So I'd like to ask a straightforward question that really is either a yes or no answer. Do these emails constitute credible evidence, not proof, but credible evidence warning further investigation into whether Steve Tisch was involved in Epstein's criminal conduct? Do you think yes or no?
Attorney General Pam Bondi sat before the House Judiciary Committee and made a definitive statement about the evidence in the Jeffrey Epstein files. She claimed that no evidence exists linking Donald Trump to criminal activity. That is a lie. This statement was made under oath. It was made in response to direct questions about the contents of millions of pages of documents released by her own department. It is a claim that ignores the very documents she was there to discuss. It is a claim that contradicts the investigative record maintained by the Federal Bureau of Investigation. By stating there is no evidence, the Attorney General is attempting to settle a legal question that she has actively prevented her department from investigating. This is a false claim designed to shield the President of the United States from legal scrutiny. Let's play this clip.
I'm not going to play a yes-no game with you, but I will answer the question to the best of my ability. As I said, we will look and investigate any case involving any victim. I'm not familiar, there were 3 million pages, of course, with that email, but of course, we will look into anything. The documents have been released, 3 million, the redacted versions, we left them open for all of you to come view. I believe you view them. If not, will you have some copies?
I'd like to.
But could I finish, please? I'm not being rude, please.
I only have 5 minutes.
No, yeah, and I only have 30 seconds based on your filibuster.
You didn't give a yes or no answer, so let me just go further. Director Patel testified in this committee room that there was no credible information indicating that Epstein trafficked victims to anyone else. And glancing at the documents, that proves that's not the case. In July, your department issued a memo stating that it had conducted an exhaustive review of the Epstein files and concluded that no additional individuals would be charged. So I did go over to the Department of Justice yesterday. I would note that 400 and all our 35 members are in the House, and there's 4 computers. So
we must look at the exact words used during the hearing. Representative Ted Lieu of California asked the Attorney General if Donald Trump had ever attended one of Jeffrey Epstein's parties with underage girls. Attorney General Bondi responded by saying there is no evidence that Donald Trump has committed a crime. She said everyone knows that. She called the line of questioning ridiculous. She claimed the administration is the most transparent in history. This was not a casual remark. It was a formal defense of the president. The authority here is the highest law enforcement officer in the country. She is the speaker. She is the person responsible for the files. When she says no evidence exists, she is speaking for the entire Department of Justice, but the files tell a different story. Let's play this clip.
take many months to actually have the time. I only had a few hours. I think the transparency argument is really kind of a sham because it's not really possible.
Whoa. Did you have to wait to get a computer?
It is not possible
Hang on.
to really go in. I did, however, see a U.S. attorney information for the Southern District of New York indicating that there were additional survivors and probable co-conspirators. Other members of Congress have uncovered likely co-conspirators whose names were blocked out. Now, the Epstein File Transparency Act, which all but one member of this House voted for and the president signed, requires the department to release everything except that it needs to be redacted to protect the victims or an ongoing prosecution, which apparently there is none from the testimony we have received. I am concerned that this act has not been fully complied with. When Director Patel came to the committee, he admitted that up to 1,000 FBI agents had gone through the files and redacted President Trump's name from them. And it's pretty clear that what has been transmitted from the FBI continues to redact President Trump's name, even though he is mentioned thousands of times in these files. So I think the credibility of the department in terms of complying with the act has been damaged. And I think the department's credibility has been damaged in other ways. I think we all saw the horrible video of American citizens being killed.
The forensic evidence found in the sources contradicts the Attorney General's claim. Representative Ted Lowe presented specific documents to the committee. He cited a tip made to the FBI's National Threat Operations Center. This tip came from a witness who was a limo driver. The driver told the FBI he overheard a cell phone conversation in 1995. In that conversation, Donald Trump allegedly told a person named Jeffrey about abusing a girl. The witness also stated that a woman he knew claimed to be abused by Epstein. That woman was later killed in a manner that police said could not be suicide. This is credible evidence. It is a witness statement that requires an interview. Attorney General Bondi's department has not interviewed this witness. Let's play this clip.
ICE agents in Minneapolis. And I think how the department has handled these cases raises a lot of doubt about the department. State and local police in Minnesota got a court order to get access to the crime scene to be sure evidence would be properly preserved by federal agents. But they took the agents defied the court order, and in a departure from general policy, the DOJ is not collaborating with state and local law enforcement on these homicides. So I really think that is a disgraceful approach to the homicides of American citizens, and really does nothing to bring credit to your department. And Mr. Chairman, I would yield back.
Gentlelady yields back.
May I answer?
Attorney General can respond.
I find it interesting that she keeps going after President Trump, the greatest president in American history. And if they could maintain their composure, this isn't a circus, this is a hearing. I find it interesting she keeps going after Donald Trump. She doesn't say how much money she took from Reid Hoffman, did you?
None.
And nor did
Mr.
she
Chairman,
post
regular
anything.
order, please.
She
Regular
posted
order.
nothing on her X account,
Gentlelady.
on her Twitter account during the Biden years.
Gentlelady.
Yet
Chairman,
now,
there
all
was
of
no
a sudden,
question
she's
asked.
going after
Committee will be in
Point of order. There was no
Committee will
question
be in
asked
order.
of the Attorney General. She doesn't just get to
Committee will be in order.
I have a point of order, Mr. Chairman.
Committee will be in order.
Point of order, Mr. Chairman.
Gentlelady can state her point of order.
There is further evidence in the Epstein files regarding the scope of the criminal enterprise. Documents show emails from an individual asking Epstein about women. Epstein responded that one woman was a civilian, Russian, and fun. In another email, Epstein wrote to Steve Tisch about a Ukrainian girl. Epstein noted that the girl was freaked out by the age difference. He stated he would try to convince her not to return to Ukraine. He then instructed Tisch to call him because he did not like records of these conversations. This proves the existence of a trafficking network involving foreign nationals and powerful associates. It proves an intent to avoid creating a record of these dealings. Let's play this clip.
When a witness attacks...
Not a valid point of order. You got to state.
She hasn't completed her point of order yet. Please let her speak, Mr. Chairman. Let's have some regular order here.
Regular order is you got to state the rule. And
I am trying to make a point of order that the witness,
And what rule are you referring to?
without responding to a question, has attacked me personally, I think it's pathetic that she can't answer the questions and
First
instead
time
is attacking
that is not even close
members
to a
of the
point of
committee.
order. The gentleman from Wisconsin is recognized.
The evidence also concerns the redaction process. Director Kash Patel testified that the FBI redacted Donald Trump's name from the files. He claimed Trump's name appeared less than 100 times. However, testimony from the committee indicates that Trump is mentioned thousands of times in these files. Up to 1,000 FBI agents were involved in the redaction process. The Department of Justice issued a memo in July stating that an exhaustive review had been conducted and no additional individuals would be charged. Yet, Attorney General Bondi contradicted her own department during the hearing. She stated that there are pending investigations in her office pertaining to the Epstein files. This contradicts her deputy, Todd Blanche, who previously told the media that no more investigations were expected. The evidence proves that the department is providing conflicting information about the existence of ongoing criminal probes. There is also evidence of surveillance. A photographer captured a printout in Attorney General Bondi's binder. That printout was titled Gipal Primula Search History. It contained a list of Epstein documents that Representative Gipal had searched for in the Department of Justice database. Representative Nancy Mace confirmed that the Department of Justice is tracking the search history of lawmakers. There are timestamps associated with this tracking. This proves the Department of Justice is monitoring the activities of the members of Congress who are tasked with overseeing the department. It proves that the department is using its technical capabilities to keep tabs on its critics. This evidence reveals a pattern of power and control. Each piece of evidence shows a Department of Justice that is functioning as a shield for the executive branch. The redaction of the president's name thousands of times is an act of information control. It is a way to prevent the public from seeing the full extent of the president's relationship with a convicted sex trafficker. The refusal to interview the limo driver is a failure of investigative duty. It is a way to ensure that potentially damaging testimony is never officially recorded or pursued. The surveillance of Representative Gayapal is a direct attempt to intimidate the legislature by tracking which documents a lawmaker is viewing. The Department of Justice is asserting control over the oversight process. It is a signal to lawmakers that their attempts to find the truth are being watched. This subverts the separation of powers. It turns a law enforcement agency into a political intelligence unit. The treatment of the victims also demonstrates this control. The Department of Justice revealed the identities of 32 survivors in the recent document release. This included names, emails, addresses, and even nude photographs. Some of these victims were Jane Does, who had been protected for decades. At the same time, the department was redacting the names of Epstein's powerful associates. This is a reversal of the law's intent. The department protected the perpetrators and exposed the victims. When the victims in the hearing room were asked if the Department of Justice had contacted them, every single one of them raised their hand to say they had not been contacted. The department is ignoring the survivors while monitoring the politicians who speak for them. The strongest defense argument offered by Attorney General Bondi is that the department is being transparent. She points to the release of 3 million pages of documents as proof of this transparency. She argues that the tight 60-day time frame for the release made mistakes inevitable. She claims that the department is doing the best it can to comply with the Epstein Files Transparency Act. This argument is dismantled by the facts of the redactions. Transparency is not achieved by releasing millions of pages if the most relevant information is blacked out. The Epstein Files Transparency Act requires the department to release everything except what is needed to protect victims or ongoing prosecutions. There are no ongoing prosecutions, according to the testimony received, yet the department continues to redact the president's name. The department also failed to protect the victims, which was a core requirement of the act. Furthermore, the Attorney General's personal behavior during the hearing undermines any claim of professional transparency. When asked difficult questions, she deflected by citing the stock market. She talked about the Dow Jones being over 50,000 and the NASDAQ smashing records. These numbers have no legal relevance to a sex trafficking investigation. She also used a binder of pre-written personal attacks referred to as a burn book. She used these notes to attack the credentials and personal lives of the lawmakers. Questioning her. A transparent official answers questions with facts. A defensive official answers questions with insults and irrelevant economic data. We must understand the law that governs this situation. The Epstein Files Transparency Act was passed with nearly unanimous support from Congress and signed by the President. This law mandates the disclosure of all documents related to the Epstein case. It provides very specific and limited reasons for redaction. It is not a suggestion. It is a legal requirement. The separation of powers is also a fundamental legal principle at stake. The legislature has a constitutional duty to conduct oversight of the executive branch. When the Department of Justice surveils lawmakers who are reviewing documents, it violates this principle. It interferes with the ability of Congress to do its job. The Attorney General also has a legal obligation when testifying under oath. Lying under oath is perjury. Representative Ted Lieu explicitly accused the Attorney General of lying when she claimed there was no evidence of a crime. If a witness statement exists in the FBI files and the Attorney General says no evidence exists, she is making a false statement about a material fact. Finally, the department's failure to collaborate with local law enforcement is a departure from general policy. In Minnesota, federal agents reportedly defied a court order to allow state and local police access to a crime scene. The Department of Justice is not collaborating on these homicides. This is a failure to follow standard legal procedures for interagency cooperation. The professional judgment and fitness of Attorney General Pam Bondi are now under question. Her conduct during the hearing was described by multiple lawmakers as pathetic. She refused to turn and apologize to the survivors sitting directly behind her. She labeled their requests for an apology as theatrics. This shows a lack of empathy for the victims the department is supposed to serve. Her reliance on a burn book to dodge questions indicates a lack of preparation and a preference for confrontation over substance. She attacked Representative Jamie Raskin as a washed-up loser lawyer. She attacked Senator Adam Schiff's legal credentials. She attacked Representative Zoe Lofgren for her social media history and donations she received. This is not the behavior of a serious legal professional. It is the behavior of a political operative. Even the president she is defending has reportedly described her as weak and ineffective to his aides. She has been characterized as an instrument of a lawless agenda. Her department is seeing prosecutors quit in droves because they are being forced to work on low-level cases while major corruption is ignored. This suggests a leadership that has lost the confidence of its own staff and the public. The authority challenging the Attorney General is not a single person. It is a stack of legal and institutional experts. Representative Ted Lieu is a former prosecutor. Representative Jamie Raskin is a constitutional law professor. Senator Adam Schiff is a former federal prosecutor who has served as the chair of the House Intelligence Committee. Representative Zoe Lofgren has served on the Judiciary Committee for decades. These individuals have seen the unredacted files. Representative Dan Goldman went to the department to review the documents. Senator Dick Durbin, as chair of the Senate Judiciary Committee, has tracked the department's orders to flag records related to the president. These are people with the security clearances and legal expertise to know when they are being misled when they say there is evidence and they point to specific witness statements and redacted names. Their professional judgment carries significant weight. The Department of Justice is currently failing in its core mission. It is failing to investigate credible leads. It is failing to contact victims. It is failing to protect the privacy of survivors while protecting the privacy of the powerful. It is failing to follow the clear mandates of the Epstein Files Transparency Act. The institutional failure extends to the Federal Bureau of Investigation under Director Kash Patel. The FBI has made premature announcements in criminal cases such as the Nancy Guthrie kidnapping, only to walk them back after detaining innocent people. The Bureau is described as being left to the whims of a director who values bravado over success. The department also attempted to indict members of Congress for exercising their First Amendment rights. A federal grand jury refused to indict these lawmakers who had urged troops not to obey illegal orders. This was an outrageous abuse of power. It was a weaponization of the justice system to silence dissent. Courts are also seeing the department's failures. Federal judges have staved off efforts to force the National Guard into cities based on the president's television viewing habits rather than data. Conservative judges are condemning the rampant lawlessness at the Department of Justice. The department is being thrown out of court when it sues jurisdictions like Chicago and Cook County. The procedural consequences of these actions are now unfolding. There are formal calls for Attorney General Pam Bondi to resign. There is discussion of impeachment based on the cover-up of the Epstein files and the protection of traffickers. Lawmakers are submitting questions for the record that the Attorney General refused to answer in person. The Department of Justice is being investigated by members of Congress for crony capitalism regarding threats to international bridges. The House is beginning to challenge the president's economic agenda and tariff programs after some Republicans broke ranks. There is no hope offered here. There is only the process. The process of oversight is continuing despite the surveillance of the overseers. The process of judicial review is continuing despite the department's defiance of court orders. The records of the Department of Justice are being exposed, and the officials responsible will eventually have to answer for their conduct. The evidence is on the table. The law is clear. The accountability will be procedural. It will be determined in hearing rooms and courtrooms. The facts of the Epstein files and the conduct of the Attorney General are now part of the permanent record. The Department of Justice is tracking the searches of the people who oversee it. The Attorney General is using a burn book to avoid answering for millions of redacted pages. The victims are still waiting for a phone call. These are the facts of the investigation. The law will now take its course. This analysis is based on the provided sources. Some details, such as the specific nature of the pending investigations mentioned by the Attorney General, remain unclear because the department has refused to provide details or has provided conflicting information. The evidence of the limo driver's statement and the surveillance of Representative Guy Paul is documented in the sources. The legal mandates of the Epstein Files Transparency Act are also documented.